But right now, we turn our attention to a series of conversations that we have already been engaged in on the show and in our province about bail reform. It's been a hot button topic in Manitoba specifically this week, and we've been building on what we understand about the system. So we learned that the alleged killer in Hollow Water was out on bail after being charged with an assault with a weapon. And then 2 of the 4 teens who allegedly committed an armed robbery at the Walmart in Winnipeg at Unicity last week were out on bail as well. On Tuesday, PC leader Abi Khan stood beside the parents of a young woman killed by an alleged drunk driver after the accused walked out of a treatment facility while on bail. So our question is, what does an official consider when deciding whether to grant an accused offender bail? How is that risk assessed? Ryan Rolston is the chief judge of the Manitoba Provincial Court. He oversees judges who make these kinds of decisions. I'm pleased to say he joins us in studio this morning with our ongoing conversations. And to be clear, he cannot comment on specific cases. Thank you so much for being here.
Yes, thank you. Good morning.
This is obviously just, in Manitoba a conversation, but across the country a conversation. I want to first get to who makes the decision, because I understand actually it's not always a judge deciding who gets bail in the province. Who else decides?
Okay, well, let me just start by talking a little bit about, I'll give you a little bit more context about how big of a job bail is. On an annual basis in Manitoba, the police are laying roughly about 40,000 charges against various people across the province. So most of those people are getting bail. And in fact, most of those people get through their whole process without breaching their bail conditions and having charges laid against them. So it is a big daily task. Judges are not the only ones who make bail decisions routinely on a daily basis. Police release people on bail. Then the next sort of step is that Crown attorneys will review files. They'll authorize release on bail. Some of those authorizations are given to the police who release the alleged offender. Other ones end up in a bail court before a judge for a consent release, but the judge is not involved in the decision-making processes to bail. So the judges are actually the third step in the process, and that's where we consider bail.
Is everyone along that process equipped the same way to assess the risk and make that decision? Because I think some Manitobans might be, not understand that the system actually, it's not always someone in front of a judge that makes that decision.
Well, we're certainly all applying the same law, if that's what you're asking. So in that respect, they are. I mean, we trust the police to do their job, and they're certainly trained and well aware of the bail provisions of the Criminal Code, and as are the Crown attorneys. So I would say that by the time cases get to us, they're usually more complex in terms of the legal decisions being made, and usually there are defense counsel involved that are putting together bail plans that are to be considered by the judge.
If there's 40,000 cases in a year, I think 40,000 charges rather.
Yeah, plus,
in a year.
so more or less. Yeah.
Do we know how many do we know the numbers on repeat offenders, like somebody who is out on bail and would repeat offend?
Well, I mean, I don't have those numbers at my fingertips. Certainly, there are people who are repeat offenders in there, and there are certainly many people who are before the courts for the first time.
So let's get to the assessment of risk. What is a judge considering when deciding whether to grant or to deny bail?
Well, first of all, I think it's important to just take a step back and remember that we're dealing with a pretrial process. So we're in a zone where people have not been tried before a court. So we have to start with the presumption of innocence. Anybody who's charged with a criminal act in Canada is presumed innocent, and that presumption of innocence follows them all the way through until a judge or a jury finds otherwise after consideration of all the facts. One of the difficulties, of course, in the early going is often the police haven't completed a full investigation, and that's not their fault. It's a long process, and therefore the Crown, the defense, and the judge don't necessarily have all of the details when it comes to that early consideration. Now, the presumption of innocence, of course, is crucial because it leads to another constitutional right, and that's the right to bail. So it is a constitutionally enshrined right in the Charter of Rights and Freedoms. And along with that, there's something that we refer to as a presumption of release. So generally speaking, the idea is that we're presuming assuming that we're going to release an alleged offender unless there's a good reason not to.
Can I ask sort of around, because some of the proposed changes when people are talking about this in the country to bail reform is around that presumption of innocence, which would be the fundamental thing that would have to change. Because the proposal is that for some that are calling for the reforms, one of the ideas is that the onus would go on if it's a repeat offender that has previously been accused and they're in front of then someone saying that they would have to prove why effectively that they are eligible for bail. They would have to show why that would be something
Right.
that they should get. What are your thoughts on that?
Well, let's just not confuse a presumption of innocence with a reverse onus and the onus of proof in terms of
Please explain.
determining
Yep.
who should be out on bail, because the presumption of innocence is a fundamental aspect. And I
Yes.
think we don't want to go there as far as presuming anyone's not innocent in this process. It would be a fundamental change. However, the criminal code already has provisions that flip the onus onto an alleged offender to show cause why they should be released. And there's a myriad and frankly growing numbers of areas, discrete areas that it's on the offender to show cause why they should be released. So that's a part of already the daily bailiwick of the lawyers and the police officers and the judges in considering bail.
What are some of the factors that might influence a judge to release a violent or repeat offender? Like, are you looking for, and forgive my ignorance, not a judge, never been a lawyer, but are you looking for remorse, rehabilitation, resources? Are you looking for some sort of change? Like, what are the things you're actually looking for in the human being that's before you?
Well, okay, so that's a good question. It's at this stage again, we're at a pretrial stage. So the criminal code has three sections or three subsections that deal with what a judge has to consider. So I'll quickly go through them and we can talk a little bit about the nuances of them. So the first one is called the primary ground, and that's a consideration of whether we think the person's going to come back to face their charges. So pretty straight up section, is this person somebody who has ties to the community, for example? So if there's somebody who may not be from the country, for example, they're just here visiting and they were to commit a criminal offense, then you might have concerns that they're going to, go back to their home and never come back to face the charges. So that's number one. Number two is whether detention is necessary for the protection of the public, including, of course, victims, witnesses in the case, having regard to all the circumstances, including any substantial likelihood that the accused would commit an offense while on bail or interfere with the administration of justice. The secondary ground. So the secondary ground is probably the most commonly relied upon section. It's really an assessment. We're doing a risk assessment about whether there's a substantial likelihood that this person is going to commit an offense. And part of that has to then go to whether or not there are conditions that can address those concerns. So I'll come back to that in a moment, but I want to talk about the tertiary ground because that's the third ground that judges and police and crowns can think about. And that's whether detention is necessary to maintain confidence in the administration of justice. So that involves a consideration of things like the strength of the Crown's case, the gravity of the offense, the circumstances surrounding the commission of the offense, and that would include things like whether a firearm has been used or allegedly used, and then the potential for a lengthy term of imprisonment. So again, that's another sort of a bigger consideration that goes to the risk, but also takes into account what the allegations are, whether there's a strong case against the accused.
I want to go back to the danger to the public, that second pillar, only because I think that maybe the average person might think, well, if you have had two previous offenses, and let's just this is an example that is not a real case, but you've been you've had charged with armed robbery twice before, you breached bail, now you're accused of an armed robbery,
Right.
and you're in front of you're in this process. It would seem logical that would then be, let's say there's been two prior convictions, that would make sense that would be a higher risk to reoffend. But do you have to look at that case in its isolation? Can you consider the previous, the previous charges?
You can consider them. You can consider an alleged offender's criminal record for sure, and we do on a regular basis in bail court. We also have to consider other things though as well, and you look to things like the strength of the Crown's case. What is the case against this person at this stage in the proceedings? And oftentimes you'll hear lawyers argue about there is a history here, but in this case, it's not a strong case. It's an identification case, and they may have the wrong person here, so that has to be factored in. The big other component to this that we haven't really talked about is what is the plan for release. So, leaving aside your example, but maybe focusing on something that's a little more simple. If we have somebody who has, let's say, substance abuse issues, their offending in the past seems to be tied to substance abuse. The allegations seem to be related to substance abuse. Logically speaking, if we can ensure that that person is not using substances, then there's no reason why they can't be in the community, as long as they can stay sober. Now, that's a very complex issue. Again, many people are released on bail on a daily basis. Many of them have substance abuse, mental health issues. Many of them need support. In fact, most of them need some supports. And it's really about whether or not there is a viable plan that offers the support that they need and can contain them in their environment to make sure that they're not falling off the rails.
There's levels of bail reform that could be possible. There's sweeping reforms, but then we've talked about assessing risk. And if you have someone that's, committed, maybe they've been shoplifting twice and then now, that would mean that everybody then is not going to be, getting bail. The risk will be assessed differently. But then there's also sort of levels where people think about, the most violent offenders, which we talked about earlier. Is there room for the system to change, in your view, around improving the bail system in this country around those that are violent repeat offenders?
Well, that's a tough question. Let me just say that it's difficult to envision a world where bail is not a part of the system. It's got to be part of the system. When somebody's put in pretrial detention, you can see very quickly that their life is put into chaos. If they have a job, that job's probably gone. In many cases, if they have a home, that home may well be gone. And this is for somebody who's presumed innocent. And you have to remember that there are people who are charged with offenses who are found not guilty of crimes down the road. The time that people spend in pretrial detention isn't something that is in any way returnable to them, especially when they've suffered some of those consequences. So I think that we have to be mindful of that when we look at bail reform. And that's not to say that there isn't, certainly room. And many amendments have been made that focus on some of those violent offenders. As you open up the criminal code, those provisions are changing on a daily basis. So I think that, could they make more reforms? I'm sure they're probably going to try. And, the lawyers, the judges, the police officers will certainly, follow the law as it is.
Thank you very much for being with us this morning and weighing in on a series of conversations. We really appreciate you being here with us.
Yeah, thank you very much.
In studio live with us, that is Judge Ryan Rolston, the Chief Judge of the Provincial Court here in Manitoba.